I'm not going to grant the judgment today. I can't do it without the proof of service. I'm not going to dismiss the matter, which I should.
Judge, I have a proof of service.
But I don't have it, Attorney Callahan.
That's not my fault, Judge. This is okay.
This matter is dismissed without prejudice.
Fantastic. I will appeal your decision. Can you sign the dismissal forthwith?
As soon as you submit it.
Well, it doesn't even do that. So, okay, thank you, Judge. Why we are adjourning it again when there's absolutely zero legal defenses. If Mr. Beal has some kind of misunderstanding about...
Are you done? Are you done?
I'm not done, no, Judge. I'm trying to make my argument for the record.
Get done.
Thank you, Judge.
Get done.
Thank you, Judge. Any dispute about...
Case of Mutual Property Management versus Robert Beal.
Good morning, Your Honor. Kevin Callahan for plaintiff, P78273. I have with me the owner of the property, Abreet Kaur.
Good morning, Your Honor.
Go ahead.
I'm sorry, Your Honor. Good morning, Robert Beal here, Your Honor.
Counsel, did you see a copy of the answer?
We received a copy of the answer by email at 4:36 last night. It's my understanding from our last court date that Mr. Beal indicated that he was having his lawyer appear. No lawyer has appeared on the case. He was required to tender $10,000 into the court's escrow by the 10th of July. I don't have evidence of that. Not to say that it didn't happen. I don't have evidence of it. And he was required to answer the complaint by the 10th of July. And we just received the answer last night that poses zero legal defenses, Judge.
Mr. Beal, do you have an attorney here?
No, Steve Wallace will be hired as of next week. The reason I did not put the escrow in Monday as you required me to and give the answer, my business partner had a stroke in Oregon. I flew to Oregon and I just got back Thursday night. And my wife has already took the funds out the account. I didn't want her to take that a lot of money up there by herself. So I told her I'd start working on that after I speak with you today. But we have all of the rent money.
That escrow was supposed to be in.
Yes, Your Honor, you're right.
Oh, I know. And all right. And the answer was supposed to be in earlier than it is now. And I don't see where you're indicating that any defenses to the amount they're claiming is owed.
The amount they're claiming is owed, we're off a few $1,000s, but not the majority of the rent. The majority of the rent of the $4,500 is definitely due. I have been going back and forth with the management company to do some things around the house, and they have yet to do everything. But the key thing was the deck and the security of the deck. They told me we were going to put a deck up. They decided not to. I asked them to let me pay for the deck. Let me pay for the deck. They said, well, you pay for it. We're not going to reimburse you for it. I said, well, what about if I sell it to you back at 30% after I leave, after the lease is up? They said, no. I said, well, if I pay for the debt, can I take it with me when I leave? They said no. So I have been trying back and forth to go back and forth with them to try to work out an agreement with the deck. I did speak with the county yesterday, Steve, the inspector, and he said by law, they're not required to put a deck up, but they are required to have a security barrier back there. So Steve said he was going to call, Steve, the inspector for the county, said he was going to call email the owner to see if they can arrange to put a barrier up. Once that barrier is up, I'm fine.
How much is owing on this account?
With court costs, Judge, it's $18,944.23. Court costs are $235.
Here's what I'm going to do in this case is I'm going to, the escrow needs to be paid. Mr. Beal, we've been through this before. You always make promises to me in another case. You always make all these promises. There's some excuse, and you're just going to have to put up or not. I mean, I ordered $10,000 in escrow. You said you were going to pay it. I get here today, you didn't do it. I don't have any proof of what are the other things that you're talking about. Don't need it, quite frankly. You were supposed to put the 10,000 into escrow. So, if the escrow is, so I will grant the judgment. If the escrow is paid, then the judgment will not enter. It needs to be paid today. If the escrow is paid today by close of business, then this matter adjourns out to July 21st, 2023 at what time? At 10 a.m. So the escrow needs to get there. If it's not here today, plaintiff's entitled to their judgment for their full amount. If it's there today, then I'll see you guys next week at 10.
Judge, if I may.
I make my orders, you got to follow.
Judge, if I may
Understood.
respond.
Pardon?
If I may respond to that, Judge.
Sure.
Judge, there's absolutely zero reason for us to adjourn this again. Mr. Beal,
Counsel,
if I could,
that is what I'm doing. I don't need a response from you. That is what I'm doing.
Judge, I would like to make a record if I could.
I go for it.
Thank you, Judge. At the second court date, we received a possession judgment for the full amount. Mr. Beal was not present. Mr. Beal decided to come later on, and the court set aside that judgment. At the subsequent hearing, Mr. Beal made promises to this court, made promises to us that he has a lawyer, he has the escrow, he has this, he has that. He didn't do anything he was required to, and there's zero legal defenses here. I don't understand why we are adjourning it again when there's absolutely zero legal defenses. If Mr. Beal has some kind of misunderstanding about...
Are you done? Are you done?
I'm not done, no, Judge. I'm trying to make my argument for the record.
Get done.
Thank you, Judge.
Get done.
Thank you, Judge. Any dispute about a deck is between the owner and the city and has nothing to do with the legal contract. It has nothing to do with Mr. Beal's obligation to tender rent. I have an owner here that has been displaced from her house. She's owed over $18,000 and is not receiving a single dime here. I don't know why you're giving Mr. Beal another opportunity when there's absolutely zero legal defenses.
All right. First of all, part of your record is wrong. And absolutely wrong, because that was explained to you the last time. So don't try to distort the record, counsel. The reason that the judgment was set aside is Mr. Beal was attempting to try to get in. We verified it. In deference to somebody trying to sign into Zoom, I set aside the judgment. I explained that to you. So don't try to distort what happened. Second thing, I told Mr. Beal this is what he needed to do. He has given me some reason why he did not do it. Certainly, I question whether or not all of that occurred. But what I did is I said, look, if you were to put the escrow in, he files the answer, we'd have to deal with that anyway. He's saying there's a reason why he didn't put the escrow in. I'm giving him till today to get the escrow in. If the escrow's not in, you get your judgment. It's as simple as that. That's why that's happening. I'm done. Case over. We'll see you next week or not. Clerk calls case. Mr. Smith, can you state your name, please?
James Smith, Your Honor.
All right. You guys want to fight with me too?
Absolutely not, Judge.
No,
No.
let's roll. I'm ready today.
I'd like to make a record.
No.
Everybody's asking me why I'm doing what I'm doing. I'm doing this 23 years and I get questioned today. Anyway, go. It does call the case of Affinity Investments versus Willie Cater.
Good morning, Your Honor. Ronald Ruark for the plaintiff, Affinity Investments.
Good morning, Your Honor. Excuse me, give me 1 minute. Had to run out my job. Good morning, Your Honor. Willie Cater here.
All right. And we're here on your motion to stay the writ.
Yes, sir.
Correct?
Yes, sir.
All right, I denied it. What's your basis for stating the writ?
My basis of stating the rent, Your Honor, is I don't have any problems with paying. I'm also entitled to a rental property that meet the basic structure, health, and safety standards also of living there, and that's not being complied with my landlord at all on several things.
But, sir, that would be a defense that you would raise in the primary case. your basis for staying the writ would be
Mhm.
payment.
All right, Your Honor, I put 1 month rent in escrow, and I have the rest of the payment also that I would rather put in escrow than to give to the landlords because of this reason right here. Now, I just feel like if I'm out here doing everything I can, even I fell behind, okay, cool, but I'm paying you now and I'm paying my money. I am also entitled to make sure that the home that I stay in is
So that
because
needs to be raised, sir. I'm not going to litigate the case again.
okay.
And you have to just separate that out.
Yes,
Counsel,
sir.
how much is owing?
Your Honor, there's still on the original judgment of possession, there's $2,730 that is still owed, and a total of
Which I have.
Mr. Cater. Go ahead, counsel.
and a total altogether for April, May, June, and July. He still owes over $11,130.
No, I don't.
$2,730 on the judgment.
No, I don't. I don't owe. Oh my God. I just answered that. No, I don't, Your Honor.
Mr. Cater, you know what? You keep talking. I'm just going to end this hearing and deny your motion.
Yes, sir.
Am I understood?
Yes, sir.
Counsel, how much is owing on the judgment?
On the judgment, $2,730. Mr. Cater did pay $2,100 on June 16th and $2,050 to the court, which I request be released to my client. So $2,730.
Oh, I understand that, but the $2,050, is that, have you already subtracted that to get to your $2,700 or no?
Yes, I have, Your Honor. He paid $4,150 on the judgment.
After I just want to make sure I'm clear. After the $2,050 is paid, then there's still $2,730?
That is correct, Your Honor.
All right. Is there anything else?
Only that he owes an additional 4 months rent. He keeps getting further and further behind.
No, I don't. Do not owe it.
The last time he said he had paid, the check bounced.
No.
I know, I was here.
So, Mr. Ward.
Mr. Cater, I already warned you once.
Yes, sir, Your Honor.
You keep saying yes, sir, but then you keep talking. There's not a basis for me to stay the writ in this case because the judgment is not even satisfied in terms of the payment into escrow. Even the payment into escrow, if paid to the landlord, would not satisfy the judgment in this particular case. And so there just isn't a legal basis. There just isn't a legal basis for me to do so. And so I'm not going to do so. Motion to stay the writ is denied. The writ will issue. Escrow to the plaintiff.
Thank you very much, Your Honor.
Mr. Simmons, can I say one thing?
I don't know why you would want. You say what you want to say and be very careful what you say to me.
Oh, no. I ain't never been disrespectful to you.
You interrupt. Go ahead.
I would rather pay the amount that's owed to the court. Is that okay?
Not at this point. You need to pay the landlord on the judgment. To stay the writ, you need to pay the landlord on the judgment. It's simple.
And the only reason I state that, okay, they will have their payment Monday, Your Honor. Thank you so very much.
Well, you got to beat the writ there. Thank you.
Thank you, Your Honor.
Can I ask you when the writ will be issued?
Mute him and kick him out of my courtroom. I'm done with him.
Thank you.
Boot him.
Will you hand me my screen box?